Appearing in the appeal, Secretary of State for Work and Pensions against Gubeladze.
Yes, Mr. Chairman.
Ladies, my lords, I appear with Mr. David Blundell and Ms. Julia Smythe, the appellant, the Secretary of State for Work and Pensions. Ms. Helen Mountfield, Queen's Counsel, and Mr. Tom Royston appear for the respondent, Ms. Gubeladze. Mr. Tom de la Mare, Queen's Counsel, and Mr. Ravi Mehta appear for the Air Centre intervening.
Yes, thank you.
Ladies, my lords, there are 4 issues for determination today. Issue 1 is whether national measures adopted under the transitional provisions of the Accession Treaty, that's the treaty by which 10 member states acceded to membership of the EU in 2004, can be challenged on the basis of proportionality. We say the answer is no, and the House of Lords' decision in Zalewska to contrary effect should not be followed. As was made clear in the Secretary of State's application for permission to appeal, this is a point that was not argued below. That being so, there are 2 answers to it, one from the respondent and one from the Air Centre, that were also not considered below, and we've summarised our responses to them in a reply document which I hope made its way to the court last week. I will expand on those answers in oral argument under Issue 1. Issue 2 arises if we are wrong on Issue 1, so that proportionality review of the kind undertaken by the upper tribunal and endorsed by the Court of Appeal is in principle available. Issue 2 is whether the upper tribunal and Court of Appeal erred in finding that the decision to extend the scheme was disproportionate. Issue 3 is whether, as the Court of Appeal held, Article 17(1)A of the Citizens Directive requires a person to show 3 years legal residence in accordance with the directive, or whether, as the upper tribunal held, actual residence, whether legal or not, will do. Issue 4 arises if we are right under Issue 3 that the directive requires legal residence in accordance with the directive. The question then arises whether, as we say, and the Court of Appeal inclined to agree, the domestic implementing regulations should be read in the same way as the directive they are designed to implement, or whether, as the respondent says, they should be read as conferring a right of permanent residence on more generous terms on those who have been actually resident, even if that residence was not in accordance with the directive. Before I address those issues, and I'm going to address them in numerical order, I want to look first at the relevant EU law at the time of accession, then at the domestic implementing legislation, next at 2 important cases, Mirga and Prefetta, both dealing with the legal consequences of non-registration under the scheme, and finally at the factual position before the Secretary of State when she decided in 2009 to extend the workers' registration scheme from the 5-year point post-accession to the 7-year point. So my first introductory topic then is the relevant EU law at the time of the accession treaty. And I want to start by looking at the rights enjoyed by EU citizens generally at the time when the 10 states became members of the EU in 2004. Now, the relevant treaty provisions in force at the time were in the EC Treaty, and that, at the relevant time, as in force at the relevant time, can be found in Authorities Bundle 2.1, tab 38, and the first relevant one is at MS 1584. and that is Article 12 EC, which later became Article 18 TFEU. And that's the general provision prohibiting discrimination on the grounds of nationality, but only within the scope of application of this treaty. Then the next relevant provision is just over the page at MS 1585, and it's Article 17, which establishes citizenship of the Union. And over the page again at 1586, Article 18, which establishes the right of every citizen to move and reside freely within the territory of the member states, but, importantly, subject to the limitations and conditions laid down in this treaty and by the measures adopted to give it effect. That is now Article 21 of the TFEU, in which the wording has changed to some extent, but for our purposes, not materially. Next, there is Article 39 EC, and that is over the page at 1587, and that's in the chapter of Title 3, which deals with workers. And it provides in paragraph 1 that freedom of movement for workers shall be secured within the community. Paragraph 2 provides that such freedom shall entail the abolition of any discrimination based on nationality between workers of the member states as regards employment, remuneration and other conditions of work and employment. And then paragraph 3 shows that the freedom entails, at B, amongst other things, the right to move freely within the member states for the purpose of employment, and at C, the right to stay in a member state for the purpose of employment in accordance with the provisions governing the employment of nationals of that state. Article 39 of the EC Treaty has now become Article 45 of the TFEU, which is in the same terms. Now, the one final provision of the EC Treaty, which is relevant here, but unfortunately has not made its way into this tab, is in the supplemental bundle, which I hope you have all got in front of you.
Do we have it electronically?
I don't know the answer to that question, but if not, I will try and ensure that that is rectified.
Well, there are some of us who...
I think we do.
We do. Is it a separate bundle or is it part of the same?
Was it? I think it was emailed to the registry, was it?
Yes, I think it was. And so certainly the MS numbers continue.
Yeah, they do, but that doesn't always work.
No. Well,
Okay.
can I undertake that if we will make some inquiries over lunch, and if there is anything further that we need to do to make it work, or that we can do to make it work, we will.
Good, thank you.
But Article 49, as I've said...
Forgive me, Mr Chamberlain, where do I find it? I'm working off hard copy.
Yes, it's in the supplemental bundle, which should be in front of you, I hope.
This additional
Yes.
authority with pagination and index
Yes.
received
I'm afraid I haven't brought.
There's a spare one if I
So
see,
I'm
yes.
relying on the.
received at 8:15
Ah.
this morning.
Sorry, maybe.
8:15.
Yep, that's it. Thank you.
Does my lord have that now?
I do know, thank you. Which tab?
So it's tab 84,
Thank you very much.
MS 2695, and Article 49 is the article which confers the freedom, or conferred at that time, the freedom to provide services. That is now Article 56 TFEU. So those are the provisions of the EC Treaty that applied generally at the time of accession in 2004. The key legislative instrument on free movement of workers in force at that time was Regulation 1612 of 68, which you will find at Authorities Bundle 2.1, tab 37, MS 1565. Now, that regulation conferred a bundle of rights on nationals of the member states to take up and pursue employment in another member state on the same terms as nationals of that host state. And it can be seen that Title I, which contains Articles 1 to 6, you'll see those on 1566 to 1567, is about eligibility for employment. And then Article 7, which is over the page at 1567, confers the right to equal treatment in respect of tax and social advantages. The term social advantages there includes benefits such as state pension credit, which is what we're dealing with here. But note from the opening words of Article 7 that the right is conferred on a worker. Now, we're going to come to Zalewska later, but for present purposes, I just invite the court to note that the House of Lords has held, in that case, that to benefit from the right conferred by Article 7, a person has to have taken up employment as a worker under Articles 1 to 6. Or, to put the point differently, a person who does not enjoy the rights conferred by Articles 1 to 6 also does not enjoy the right conferred by Article 7. Now, the provisions of the Accession Treaty, which is what we are principally concerned with here, are in Authorities Bundle 1.1, tab 4, and one can take it up at 565, MS 565. One goes up the page to 566. One can see the list of recitals to the treaties, and the last recital, about a third of the way down, 566, the parties have decided to establish by common agreement the conditions of admission and the adjustments to be made to the treaties on which the European Union is founded, and to this end have designated the following as their plenipotentiaries. On 570, Article 1.1 provided that the accession states were to become members of the EU and parties to the treaties on which the Union is founded, as amended or supplemented. And 1.2 provides that the conditions of admission and adjustments to the treaty entailed by such admissions are set out in an act annexed to the treaty. 2.1 provides that the treaty is to come into force on the 1st of May 2004. And we can then move to the Act of Accession itself, which is the act that modifies the treaties and provides the conditions of admission for the new accession states. So that begins at 580. And one can see there in Article 2, the top of the right-hand column of 580, from the date of accession, the provisions of the original treaties and the acts adopted by the institutions before accession shall be binding on the new member states and shall apply in those states under the conditions laid down in those treaties and in this act. Article 7, which is over the page at 582, bottom of the right-hand column, provides that the provisions of the Act of Accession cannot be suspended, amended or repealed other than by means of the procedure laid down for revising the original treaties. That gives the Act of Accession the same jurisprudential status in the EU legal order as the original treaties. And Article 10 over the page at 583 provides that the application of the original treaties and acts adopted by the institutions shall, as a transitional measure, be subject to the derogations provided for by this Act. Article 24, which is on 587, provides that the measures listed in Annexes 5 to 14 shall apply in respect of the new member states under the conditions laid down in those annexes. Now, the scheme of the Act of Accession is that there was a separate annex numbered between 5 and 14, applicable to each of the new accession states. So slightly different provisions applied in relation to the different joining states. The one we are concerned with for the purposes of this appeal is Latvia, and that is dealt with in Annex 8, which starts at page 597. Now, one can see from paragraph 1 of Chapter 1. Chapter 1 deals, as you can see from the top of the page, with freedom of movement for persons. And paragraph 1 of that chapter provides that Article 39 and the first paragraph of Article 49 EC shall fully apply only in relation to the freedom of movement of workers and the freedom to provide services involving temporary movement of workers between Latvia and the other member states, subject to the transitional provisions laid down in paragraphs 2 to 14. Paragraph 2 provides, in its first subparagraph, that by way of derogation from Articles 1 to 6 of Regulation 1612/68, Member States will apply national measures regulating access to their labour markets by Latvian nationals for the first 2 years, and may continue to apply such measures until the end of the 5-year period following accession. The subsequent paragraphs of Article 2 then contain a series of cases in which Latvian nationals will acquire and retain access to the labour market of a member state, essentially where those nationals had already been working in a present member state for an uninterrupted period of 12 months or longer at the date of accession, and where they were admitted to the labour market for an uninterrupted period of 12 months after accession, provided in both cases that they do not voluntarily leave the labour market. Paragraph 3 then requires the Council to review the functioning of the provisions before the end of the first 2-year period on the basis of a report from the Commission. Then Member States must notify the Commission of the choice that they make. And one can see from paragraph 3, it's a binary choice in the first instance. They must notify the Commission whether they will continue to apply national measures up to the end of the 5-year period to 2009, or, on the other hand, apply Articles 1 to 6 of Regulation 1612. And the default position, if they fail to notify, is that Articles 1 to 6 of Regulation 1612/68 will apply. Paragraph 4 then provided for Latvia to request a further review. And then there is paragraph 5, which is of central importance to this case. That permits a member state which has chosen to maintain national measures up to the 5-year point to continue to apply those measures up to the 7-year point in case of serious disturbances of its labour market or threat thereof, and after notifying the Commission. Paragraph 6 deals with member states which choose to require work permits, so it's not directly relevant in the United Kingdom. Paragraph 7 applies to those member states which have decided to apply Articles 1 to 6 of Regulation 1612/68, i.e. those which, when faced with the binary choice I mentioned a moment ago, decided not to apply national measures, but rather to admit Latvian nationals without restriction, either in years 3 to 5 or in years 6 and 7. And it provides a mechanism where a member state in that position can request the Commission to state that the application of Articles 1 to 6 is wholly or partially suspended, but only where the state, quote, undergoes or foresees disturbances on its labour market which could seriously threaten the standard of living or level of employment in a given region or occupation. And one can see from the wording in the middle of the second subparagraph of Article 7, of paragraph 7, the purpose of the suspension must be, quote, to restore to normal the situation in that region or occupation. There is over the page at 598, in the last subparagraph of paragraph 7, a power in the member state to act unilaterally in urgent cases, followed by a reasoned ex post notification to the Commission. Now, the respondent says, and this is at paragraph 31 of her case, MS 163, that the UK could have exercised powers under paragraph 7. But that is, with respect, wrong, because the UK, having chosen to apply national measures in 2004, is not a member state in which Articles 1 to 6 of Regulation 1612/68 apply. In any event, paragraph 7 wouldn't help the UK because the only purpose for which a member state can request the suspension of Articles 1 to 6 of Regulation 1612/68 is in order to restore the normal situation in a region or occupation. And it was not suggested that the measures applicable in the UK would be capable of doing that. Paragraph 8 contains further detailed provisions relating to family members. Paragraph 9 allows member states which are derogating from Regulation 1612/68 also to derogate from Directive 68/360/EC insofar as the provisions of the latter cannot be dissociated from those of the former. Paragraph 10 provides that where a member state adopts national measures in relation to Latvian nationals, Latvia is entitled to maintain in force equivalent measures in relation to the nationals of that state. And paragraph 13, which is at of some interest, even though it doesn't apply to the UK, is a specific provision applicable to Germany and Austria, and it permits further derogations from Article 49 EC, that's the freedom to provide services, in order to address serious disturbances or threat thereof in specific sensitive sectors on their labour markets. Now, pausing there, ladies and lords.
Sorry, why is that of particular interest in this case?
Well, because there is a contrast between the wording which you see in paragraph 5 on the one hand and the wording which you see in paragraph 7 and paragraph 13 on the other hand. So if one looks at the opening words of paragraph 13, they are in order to address serious disturbances or the threat thereof. And those words do not appear in paragraph 5. Similarly...
Right, well, I think I've got that, but what's the significance in relation to this case?
Well, the significance is that it helps to address a point which is made by Mr. de la Mare on behalf of the Air Centre, that there is a jurisdictional precondition which we have not satisfied here.
I see.
Yeah, the purpose of continuing the controls has to be to do something about the serious disturbance.
Yes,
And you say they can be temporally related, they don't have to be causally related.
yes. And we do say that, and I'll come to address exactly how Mr. de la Mare puts his asserted jurisdictional requirement in a moment. He inserts, no doubt with great forensic skill, the word material into his requirement because he wants to assert a requirement which, on the basis of the evidence before the Secretary of State here, can't be met. We say if you look at the wording of paragraph 5, and I'm going to make these points in just a moment in detail, but if you look at the wording of paragraph 5 and you compare it with the wording of paragraph 7 and paragraph 13, there is a very obvious difference. There is no in order to, and there is no, as in paragraph 7,
When?
to restore the situation ex ante, which you do find in paragraph 7. So we make 5 points about these provisions. First, we say that prior to accession, no national of any accession state had any right whatsoever under the EU treaties. That's obvious. Second, the provisions of the annexes contain what the treaty, in its 6th recital and in Article 1.2, refers to as the conditions of admission of the accession states. These conditions of admission involve the conferral of a bundle of rights that differs from those enjoyed by nationals of the existing member states. Thirdly, and crucially, the contracting parties decided that for nationals of the A8 states, 8 of the 10, minus Malta and Cyprus, during the first 5 years after accession, this bundle of rights would not include free movement rights as a worker or any of the rights to equal treatment flowing from that status if the member state chose to apply national measures regulating access to its labour market. Fourthly, the annexes themselves contain detailed and specific provisions in paragraph 2 for A8 nationals who had been legally working in the member state for an uninterrupted period of 12 months and who had not voluntarily left the labour market in that state. Under the scheme agreed by the contracting parties, they were entitled to the full benefit of the provisions governing free movement for workers. Others were not. Fifthly, in paragraph 5, it was envisaged that a member state which chose to apply national measures up to the 5-year point would be free to continue to apply those measures up to the 7-year point, subject only to 2 conditions. First, that there was a serious disturbance in its labour market or threat thereof. And secondly, that it had notified the Commission. Whereas Article 7 enables member states which had not adopted national measures to request the Commission to suspend free movement rights in order to restore to normal a labour market disturbance, which could seriously threaten the standard of living or level of employment in a given region or occupation. And Article 13 uses similar language, in order to. Article 5 places no such limit on the purposes for which a national measure may be adopted. Now, the next important EU instrument is Directive 2004/30/EC, usually known as the Citizens Directive. That is in Bundle 11, Tab 1, MS 490. Now, Article 1 of the Citizens Directive is, well, actually, before we get to Article 1, perhaps I can just ask you to look at recitals 17 and 18, which are on 495 and 496. "17 provides that enjoyment of permanent residence by union citizens who've chosen to settle long-term would strengthen the feeling of union citizenship and is a key element in promoting social cohesion, one of the fundamental objectives of the union. A right of permanent residence should therefore be laid down for all union citizens and their family members who have resided in the host member state in compliance with the conditions laid down in this directive during a continuous period of 5 years without being subject to an expulsion measure." So that explains, and I'll be coming on to this under issue 3, that the right of permanent residence conferred by the directive was an innovation in EU law brought about or enacted by the Citizens Directive. And then over the page at 18, in order to be a genuine vehicle for integration into the society of the host member state in which the union citizen resides, the right of permanent residence once obtained should not be subject to any conditions. So it's a very important and valuable right. I'll come back to that later. Going on then to page 500, you can see from Article 1 that the directive lays down the conditions governing the exercise of the right of free movement and residence within the territory of the member states, picking up the language of what was Article 18 EC and is now Article 21 TFEU. One can see from Article 1B that the directive confers a right of permanent residence. Again, we say that was an innovation and that this is an important point for the purposes of issue 3. Article 6, which is on MS 505, confers an initial right of residence for up to 3 months. And then Article 7 confers a right of residence for more than 3 months, but only for workers, self-employed persons, those who are self-sufficient, and students who are self-sufficient. And then Article 7.3, which is over the page, treats certain people, those who are temporarily ill or unemployed or engaged in vocational training, as workers or self-employed persons for the purposes of that article. On MS 516, you can see Article 14 lays down conditions for the exercise of the rights conferred by Articles 6 and 7.
My recollection is that Article 7.3 is not an exhaustive list.
Leadership may well be right about that.
Another case we've had
Yes.
relating to it, but it's not relevant to this, so matters.
I'll deal with that later if I may, once
Don't
my
worry,
juniors
no.
have told me the answer to it. So, Lady, Article 14, provides that EU citizens have the right of residence conferred by Article 6 only for as long as they do not become an unreasonable burden on the social assistance system of the host member state. And 14.2 makes clear that the right of residence under Article 7 applies only to those who meet the conditions set out in that article. Article 16, which is again going to be important when we look at issue 3, contains the general rule for EU citizens and their family members. 16.1 provides that EU citizens who have resided legally for a continuous period of 5 years in the host member state have the right of permanent residence there. And the right is not subject to the conditions provided for in Chapter 3. As we saw from Recital 17, it's an unconditional right. Article 16.2 provides that this right applies also to family members who have legally resided with the EU citizen for a continuous period of 5 years. And 16.4 over the page provides that the right of permanent residence can only be lost through absence from the host member state for a period exceeding 2 consecutive years. Now 17, which is headed Exemptions for Persons No Longer Working in the Host Member State and Their Family Members, provides that by way of derogation from Article 16, the right of permanent residence in the host member state shall be enjoyed before the completion of a continuous period of 5 years of residence. We say that's an obvious reference back to Article 16, and the omission from that first sentence of the word legal cannot possibly be regarded as significant because it is simply a reference back to Article 16. And it provides, by way of derogation from Article 16, that the following categories will acquire or enjoy the right of permanent residence before the 5-year point. And then category A, which is what we're dealing with here, are those who have reached retirement age in a member state, provided they've been working in that state for a continuous period of 12 months, and have resided there continuously for more than 3 years. Now, issue 3, as I've said, concerns the proper interpretation of this provision. We say the Court of Appeal was right to hold that the residence required by Article 17.1a, like that required by Article 16, from which it derogates, is legal residence. And by legal residence, we mean residence in accordance with the directive. Ms. Mountfield, on the other hand, argues that for Article 17, any residence will do, even if it is not legal under EU law. Article 24.1.
Presumably your argument is that there's an indispensable interconnection between Article 16 and Article 17.
Yes.
And you can't read Article 7. Well, I think you've made this point in your printed case. You can't read Article 17 out of its context.
You can't. And when one looks at that, I suppose our first point really is that when one looks at that opening sentence, before you get to A, B and C, by way of derogation from Article 16, the right of permanent residence in the host member state shall be enjoyed before completion of a continuous period of 5 years. Well, that is a reference back, and it's quite clear from Article 16 that that continuous period of 5 years must be a period of legal residence in accordance.
You see the shorter period that the derogation allows must be of the same nature. That's essentially the question.
Yes. The derogation is in terms of time, not quality of residence, if I can put it that way. Article 24.1, which you see in 524, confers on 525 confers on citizens residing on the basis of this directive a right to equal treatment with nationals of the host member state, subject to Article 24.2, which provides that member states are not required to confer entitlement to social assistance on job seekers. And then 28.2, which is at 528, confers on those with a right of permanent residence the very important right not to be expelled, save on serious grounds of public policy or public security, which terms have been restrictively construed. So that simply makes the point that the right of permanent residence is an important and valuable right. It gives rise to key protections which are not available to those who do not enjoy the right. Can I turn then to the UK legislation which implements this? Implements the EU provisions that we've been looking at. The first piece of relevant implementing legislation is the Accession, Immigration and Worker Registration Regulations 2004, and I'm going to invite the court to look at the version in the supplemental bundle at tab 85 at MS 2697. The reason for that is that this is the version, and I'm afraid that the index to the supplemental bundle is wrong in this respect. This is the version which was in force at the end of the transitional period, i.e. on the 30th of April 2011.
Sorry, which tab is it?
It's
85.
tab 85. Now, if one looks at 2698, Regulation 1.2i defines relevant accession states as the A8 states. J defines self-sufficient person as having the same meaning as in the 2006 regulations, which I'm going to come to, EEA regulations. K defines worker as a worker within the meaning of Article 39 EC. And then over the page at 2699 to 2700 is Regulation 2, and that defines the term accession state worker requiring registration. The definition excludes those categories of workers who, under paragraph 2 of Chapter 1 of Annex 8, are not subject to the derogations and are therefore entitled to access the labour market without restrictions. In other words, those who had at the time of accession already been legally working in the UK for 12 months, or who worked legally for a continuous 12-month period after accession. Everyone else is an accession state worker requiring registration. Now, regulations 4 and 5, which are at 2704 to 5, define the term accession state worker requiring registration. They contain the UK's derogation from the free movement rights contained in Article 39 EC and Articles 1 to 6 of Regulation 1612/68. So 4.1 contains the main derogation. 4.2 disapplies the right of residence that would otherwise arise for the purposes of seeking work. 4.3 provides that an A8 national can come to the UK as a self-sufficient person. 4.4 provides that an accession state worker requiring registration shall only be entitled to reside in the UK in accordance with the 2006 EEA regulations as modified by Regulation 5. And Regulation 5 goes on to modify those regulations in respect of accession state workers requiring registration. 5.2 provides that an accession state worker requiring registration is to be treated as a worker for the purposes of the 2006 EEA regulations only during a period in which he is working in the United Kingdom for an authorised employer. Regulation 7 in 2707 provides that an accession state worker requiring registration is only authorised to work in the United Kingdom for an authorised employer. The mechanism is that an A8 national has to apply within 1 month of starting work, and provided that he or she does so, can then continue to work until the certificate is received, see 7.2b. If, however, the A8 national applies after the first month, the employer becomes an authorised employer only from the date on which the certificate is received, see Regulation 7.2c. And the certificate applies only to work for that particular employer, see Regulation 7.5, which means that one has to re-register when one changes employer. Regulation 9, which is on MS 2711, makes it an offence for an employer to employ an A8 national if the employer is not an authorised employer. So you will have seen in those implementing regulations reference to the 2006 EEA regulations. Those are in Bundle 1.1, Tab 8, MS 633. These are no longer in force, but they were in force at the time of the Secretary of State's decision in this case. And at 639, there is Regulation 4.1a, which defines worker as meaning a worker within the meaning of, it's now Article 45 of the TFEU, was then Article 39 EC. Then, if one goes forward to Regulation 7, capital A, on MS 646, that was inserted to deal with the position of persons who, on the 30th of April 2011, were accession state workers requiring registration. They are now given a new descriptor, accession workers. And 7A5 provides that an accession worker is to be treated as having resided in accordance with these regulations during any period in which he or she was legally working in the UK, or was a person to whom Regulation 5.4 of the regulations apply. That latter limb is not material for our purposes. Regulation 13 on 661 gives an EEA national an initial right of residence in the UK for 3 months. That, you'll recall, implements Article 6 of the Citizens Directive. Regulation 14.1, then, over the page, confers an entitlement to reside in the UK on a qualified person for so long as he remains a qualified person. That implements Article 7 of the directive. To see who is a qualified person, you then have to go back to Regulation 6, which is on MS 643, and that includes, so far as material for our purposes, a worker. But as we've seen from the 2004 regulations, an accession state worker requiring registration is treated for these purposes as a worker only when working for an authorised employer. We then go back to Regulation 15, which is on 663. That deals with the right of permanent residence. It provides that certain categories of person will acquire the right of permanent residence. These include, at A, an EEA national who's resided in the UK in accordance with these regulations for a continuous period of 5 years. And at C, a worker or self-employed person who has ceased activity. But that term, worker or self-employed person who has ceased activity, is itself defined in Regulation 5. We go back to that, that's at 641. To 2. And Regulation 5.2 deals with those who retire. So it provides that a person satisfies the conditions in this paragraph if he terminates his activity as a worker or self-employed person and has reached the age at which he's entitled to a state pension on the date on which he terminates his activity, or in the case of a worker, ceases to be working to take early retirement. Pursued his activity as a worker for at least 12 months prior to termination and resided in the United Kingdom continuously for more than 3 years prior to termination. Now, you will see, I hope, that that tracks the wording of the provisions of the directive which it implements. Issue 4 concerns whether, as we say, and the Court of Appeal inclined to agree, the words resided in the United Kingdom continuously for more than 3 years refer to residence that was legal under EU law, or whether, as Ms. Mountfield argues, the legality of the residence as a matter of EU law doesn't matter. We say, in short, that you should read these implementing regulations in the same way as you read the directive. There is nothing at all to indicate that the United Kingdom was intending to confer a more generous right than was conferred by the directive. They should be read in accordance with the directive.
Can I just pick up a point which I looked at before? Paragraph Regulation 21
Yes.
deals with, on page 680,
Yes.
deals with decisions taken on public policy grounds. And that, to some extent, I think, mirrors the equivalent provision in the Citizens Directive.
Yes, Article 28 of
Yeah,
the Citizens
and
Directive.
you have the, as far as people who've got permanent right of residence, you can only exclude those on serious grounds of public policy.
Yes.
And then you have 4, relevant decision may not be taken except on grounds of imperative grounds of public security in respect of a national who has resided in the United Kingdom for a continuous period.
Yes.
And that wording, I think, reflects the Citizens Directive, which talks about residing rather than lawfully residing. Is there any, I have a sort of feeling that that's been subject to discussion in the cases.
Yeah, yes, it has. It's been construed, that phrase of tenure was one of the points that we make actually under under issue 3, that phrase resided for 10 years has been construed as meaning resided for 10 years and has acquired a permanent right of residence. And that precise question was put to the Court of Justice, and I'm afraid just right now the name of the case escapes.
Vomero.
It's from
That's for Mero, is it? Oh, I see
Mero.
that. I've always read it somewhere.
I remember it well.
FV Italy. But that case decides that the words, although the plain word of the directive is simply resided, one has got to read in because of the purpose of these provisions and has acquired a permanent right of residence.
You say that gives some support to your
Yes,
approach.
we do. Now, the decision to extend the workers' registration scheme, which is what is actually challenged in these proceedings, was given effect in the 2009 regulations, and that's in Bundle 1.1, tab 6. MS page 620, and it's a very short instrument made by the Minister of State at the Home Office. Simply takes out the date 2009 and puts in the date 2011. So it extends from the 5-year post-accession point to the 7-year post-accession point. Now, there is in the bundle an explanatory memorandum which accompanied those regulations, and that is in Authorities Bundle 2.1, which tab 43, MS 1662.
Did you say 1162?
No, 1662.
Sorry.
And it's actually over the page at 1663, the relevant part. Paragraph 7.2 makes clear that 7.2 simply records the 2004 regulations provided for the workers' registration scheme to continue beyond until the end of April 2009 on the basis that any further continuation beyond that point would need to be subject to an assessment of the labour market service circumstances at that point in time. That labour market assessment has recently been undertaken by the Migration Advisory Committee, the MAC, and in the light of the MAC's advice, it has been decided that the WRS should continue until the end of April 2011. So that is the official document which incorporates or endorses or adopts, if you like, the MAC's advice.
So you accept that the rationale for the extension has to be found in the MAC
Yes.
advice and nowhere else?
Now, the final set of relevant UK legislation is the State Pension Credit Act 2002, which I need to just show you briefly, and the regulations made under it. So the 2002 Act is in Bundle 1, Tab 9, MS 721. And at 722, you can see from section 1.2a that a claimant is entitled to state pension credit if he is in Great Britain. It's a slightly odd drafting technique.
But that's what they do.
I know.
It's not your fault, Mr. Chamberlain, it's just what they do.
Yes. And one can see from 1.5 that regulations can specify circumstances in which a person is to be treated as being in Great Britain. It's a drafting fiction. The regulations then provide in Regulation 2.1, which you have at MS, in the next tab, tab 10, MS 725, that a claimant, that in effect you are not in Great Britain if you are not habitually resident. Regulation 2.2 then provides that no person is to be treated as habitually resident unless he has a right to reside other than a right to reside falling within paragraph 3. That excludes, among others, A, persons exercising the initial right to residence under Article 6 and Regulation 13 of the 2006 regulations, B, persons exercising the extended right of residence who are job seekers or family members of job seekers, and BB will be relevant in relation to a case I will come to later, Zambrano carers. And then at 2.4, you can see that a person is not to be treated as not in Great Britain. In other words, he or she is entitled to the benefit irrespective of habitual residence. And then the categories to which that applies include at ZA, workers and self-employed persons for the purposes of Regulation 6 of the 2006 regulations. But, as we've seen, an A8 national is such a person only while working for an authorised employer. And at ZC, persons with a permanent right of residence under Regulation 15 of the 2006 regulations. Now, before leaving my introductory section on the law, I'm afraid it's rather a complicated section. Before doing that, I want to show you two cases which deal with the legal position of an A8 national who has not been working for an authorised employer for at least 12 months. And I hope that when you see these two cases, the provisions that we have looked at will fall into place and become more understandable. The first case is Mirga, which is a decision of this court, and it's it is at Authorities Bundle 13, tab 30, MS 1379. And you can take the facts from the head note. There were two joined cases, of which the first is of particular relevance to us.
So sorry, what was the MS page again?
It's 1397.
9-7. Ah, I think you said 7-9.
I do.
I apologise.
Here we are, yes.
The facts can be taken from the head note. As I said, there were two cases. We're concerned with Ms. Mirga's case. She was a Polish national. She worked for an authorised employer for 7 months, and then somewhat later, after becoming pregnant, she sought to claim income support. That was refused because she had not been in registered work for a continuous period of 12 months. She said, well, I'm a worker and my employment has been interrupted by pregnancy, and for that reason there's been a violation of my right freely to reside within the territory of the Member States as guaranteed by Article 21.1 TFEU, because the denial of income support is going to force me to return to Poland. Now, the claim failed, and Lord Neuberger, with whom the other members of the court agreed, summarised the effect of the Act of Accession at 14. I'm not going to read out the whole of that paragraph, but the last part of that paragraph is important. He was dealing, of course, there with the annex, which is applicable to Poland, Annex 12.
So sorry, which page are you?
I'm sorry, 1403. So he was dealing with the effect of Annex 12, but the provisions of Annex 12, as we'll see in a moment, are materially identical to the ones that we're dealing with here. So long as these provisions were enforced, they enabled a host member state to exclude Polish nationals from freedom of movement rights unless they had been working in that state for an uninterrupted period of 12 months following accession. That's his summary of the relevant provisions. Now, if we then go forward, and there's a lot in this case, but I'm just going to take you to a couple of passages, if I may. At 43, you can, MS 1409, the general right in Article 21 to move and reside freely within the territory of the member states was, Lord Neuberger held, subject, it was qualified by the words, subject to the limitations and conditions laid down in the treaty and in the measures adopted to give them effect, and those included both the Citizens' Directive and the Accession Treaty. Then at 45, on the same page, Lord Neuberger concluded that because Ms. Mierga had not done 12 months' work in this country, she could not claim to be a worker and so could be excluded from the right to social assistance. There was then a consideration of the question whether Ms. Mierga could challenge the decision to refuse her income support on the ground that it was disproportionate in her particular case. And the answer to that was given at 69. Where a national...
MS.
I'm sorry, 1415. Where a national of another member state is not a worker, self-employed or a student, and has no or very limited means of support and no medical insurance, as is sadly the position of Ms. Mierga and Mr. Samin, it would severely undermine the whole thrust and purpose of the 2004 directive if proportionality could be invoked to entitle that person to have the right of residence and social assistance in another member state, save perhaps in extreme circumstances. It would also place a substantial burden on a host member state if it had to carry out a proportionality exercise in every case where the right of residence, or indeed the right against discrimination, was invoked. So that then is the case of Mierga. The second case of relevance is a recent decision of the Court of Justice called Prefeta, also about a Polish national. That is, although the Advocate General's opinion is in the main bundle, the Court's judgment is in the supplemental bundle at tab 89, MS 2739. The facts of that case can be taken from paragraphs 21 to 22 of the Court's judgment on MS 2745. Mr. Prefeta, as I've said, was a Polish national. He worked in the United Kingdom from July 2009 to March 2011, but he was only registered for the last 2 months of that period. The questions that were referred by the upper tribunal can be seen from paragraph 30 over the page on 2746. Question 1 was whether Annex 12, the Polish annex, permitted member states to derogate from the benefits of the relevant EU legislative provisions, Article 7.2, in this case, of the successor to Regulation 1612 of 68, which guarantees workers equality in tax and social advantages, and Article 7.3 of the Citizens Directive, which allows worker status to be retained in certain circumstances. And question 2 was whether, if not, a Polish national could rely on Article 7.3 of the directive. Now, the substance of the answer begins at paragraph 40. Key paragraphs for these purposes are 47 on 2748. That confirms that the purpose of the UK's regulations was to restrict the right of economically inactive accession state nationals in the UK for the purpose of seeking work. And at 49, the court notes that this finding, the finding at 48, which is that the Act of Accession permits the United Kingdom not to apply Article 7.3 in the circumstances of the present case. This finding cannot be called into question by the fact that Mr. Profeta had worked unregistered for 20 months. That was because, see paragraph 50, the Act of Accession requires Polish nationals to satisfy 2 conditions. First, they had to work uninterrupted for 12 months, and second, they had to be admitted to the labour market of the member state. As regards the second condition, see paragraph 51, the UK regulations made admission to the labour market conditional on registration, and Mr. Profeta was not registered. Ultimately, see paragraph 55, the Act of Accession had to be interpreted as permitting the UK, during the transitional period, to exclude a Polish national from the benefits of Article 7.3 of the Citizens Directive. Now, it may be noted that Ms. Gubeladze is in the same position as Mr. Profeta in that she did not register when she first arrived. She was not, therefore, admitted to the labour market when she arrived, and until she had been admitted and had then thereafter worked for an uninterrupted period of 12 months, she could not claim either the status of worker or the benefit of the provisions of Article 7 of the Citizens Directive. So that pair of cases explains what the effect in EU law and in domestic law is if somebody comes to the UK, an A8 national comes to the UK but does not register with an employer. The third part of my introductory submissions, and I'm afraid I'm still on my introductory submissions, concerns the decisions to make and extend the workers' registration scheme. And you've seen from the explanatory memorandum which accompanied the extension regulations that the Secretary of State's reasons for extending the scheme in 2009 are contained in the Migration Advisory Committee's report of that year. So before I go to that, I'll just, without, one needs to turn it up, but we've set it out at paragraph 42.4 of our case on MS 136, a description by the Court of Appeal of what the Migration Advisory Committee is. The Court of Appeal described it correctly, we would say, as a non-departmental public body consisting of distinguished economists and migration experts who provide independent evidence-based advice to government on migration issues. The committee's membership, the MAC report, is in the core volume at MS 290, and if one goes to, it starts at 286, but the membership can be seen from 290. The chair was Professor David Metcalfe, CBE, Sir David Metcalfe, as he now is, of the LSE, and the membership is then set out. A short summary of the question posed and the answer given can be found in the chairman's foreword at 289. The committee was asked to consider what the likely labour market impact of relaxing the transitional measures would be and whether it would be sensible to do so. The answer was that the UK labour market was seriously disturbed, that disbanding the WRS would not have large labour market impacts, but on balance would probably cause labour inflows to be a little larger than otherwise, and some of the inflow may displace UK workers. The WRS also provides, it was said, useful data for monitoring immigration, which would be lost. Now, the summary, much is made by the Upper Tribunal and the Court of Appeal, and indeed by the respondent, of the slightly differing terms in which the conclusions appear at different points in the MAC report. But I'm going to take you to the all the relevant paragraphs so you can see exactly how the MAC put its conclusions. The summary at 291, third bullet. There is currently a serious disturbance to the UK labour market. I should just interpose at this stage. I don't think anyone is suggesting that conclusion was wrong, or indeed that any other conclusion was realistically open to the MAC in 2009, right in the midst of the financial crisis, first quarter of 2009. And maintaining the WRS would help address that disturbance. We'll come to see by how much they think it would help to address the disturbance, and the answer in short terms is by a small amount. But one can then see at the bottom of that page, after dealing with the question whether the UK labour market was seriously disturbed, there is then the heading, would retaining the WRS help to address the disturbance? And one can see, first bullet point, that the impact of A8 immigration to date has been negligible, but the studies that had been done at that point relate to a period of sustained economic growth prior to the current recession, and examination of the potential labour market impacts and review of the evidence available suggests that removing the WRS would not result in substantial increases in flows of A8 immigrants. It is, however, plausible to argue that it would probably result in a small positive impact on immigration flows relative to what would happen otherwise. In the current economic climate, we are concerned that these additional flows would have a small negative impact on the labour market, thus exacerbating the serious labour market disturbance. And we then have the conclusion that we believe it would be sensible to retain, even though the effects would be small, it would be sensible to retain the WRS for 2 more years due to the possibility of small but adverse labour market impacts from abolishing it. Then, under the heading Other Factors, there would also be a loss of data. That was another matter which was mentioned in the MAC report. The structure of the report is then as follows. Chapter 1 is an introduction. Chapter 2 gives the background to the Workers' Registration Scheme and to A8 immigration since 2004. Just draw attention on page 297 to paragraphs 2.8 and 2.9. They describe the purpose of the original scheme in terms of monitoring. It's right to note that in 2004, no disturbance in the UK labour market was observed or threatened, so avoiding such a disturbance did not at that time form part of the aim of the original scheme. But the position had, of course, changed because of changes in the economy by 2009. Chapter 3 then explains the approach that the MAC took to the issue, and the key introductory section is at MS 305, paragraph 3.2. The committee notes that one could ask the question whether removal of the WRS would cause a serious disturbance or threat thereof, Or one could ask a different question, whether there is currently a serious disturbance and maintaining the scheme would help to address that disturbance or the threat in some way. From 3.3, so the committee was absolutely alive to the different ways of putting the point, and at 3.3 they are quite clear that their focus is on the latter approach. At 3.16 on page MS 307, perhaps one can go back to 3.15. They posit two different mechanisms by which removal of the WRS could cause or exacerbate a labour market disturbance by affecting labour supply. The first is by alteration of flows of A8 nationals into and out of the UK. And the second is by changing the behaviour of all workers in all or certain parts of the labour market. So 3.16 deals with the first, and it says this, that removing the WRS could potentially increase the volume of inflows relevant to what would have happened otherwise if, and then a set of possibilities is there set out. Over the page at MS 308, paragraph 3.17, the above implies that all else being equal, removal of the WRS will cause a rise in flows. The magnitude of this impact will depend on the scale of the response of inflows and how these are expected, for example, using estimates from previous studies, to affect the labour market. 3.17 reports a conclusion that there will be an effect. 3.18 deals with the second posited mechanism by which removal of the WRS could have an impact on the labour market. And some of these can go in different directions, and that's why at 3.19 it is said the direction of the impact of the above hypothetical possibilities of this second mechanism is in most cases ambiguous. Some changes may result in positive impacts, whereas others may be negative. So you will see that having disaggregated these two mechanisms, it's the first mechanism that the MAC relies on for its conclusion as to what effect removing the WRS will have on labour market conditions. Chapter 4 then deals with the condition of the labour market and its implications, with the question of whether it is seriously disturbed. We can skip over that because no one is suggesting it wasn't. And then Chapter 5 attempts to address the impacts of removing the WRS. 5.3 on page 321 properly points out the limitations in the available evidence. So this document, if I can put it in this way, is certainly not whitewashing the position. It's facing up to the limitations in the evidence. But then 5.4, on balance, however, we believe there is sufficient information available for us to draw broad conclusions regarding the advisability or otherwise of retaining the WRS. Then at 5.60, 5.6 and following on pages 322 to 323, I'm not going to read out these paragraphs, they address essentially the first mechanism that we have looked at, by which removing the WRS could could have an impact on the labour market. And then at 5.16 at the bottom of 323, in conclusion, it's very unlikely that removing the WRS would result in any substantial change in aid to immigrant inflows. However, it is possible that some factors, including the 90% registration fee, could have a small effect at the margin. The effect of maintaining the WRS will be to slightly reduce flows relevant to what would otherwise be observed. We argue in this report that this slight dampening effect on flows is a positive phenomenon in the current economic circumstances, which is why we have not given detailed consideration to the option of relaxing the WRS by keeping the scheme but abolishing the £90 fee. So that's the conclusion at 5.16.
What is the conclusion? It is possible that some factors could have a small effect at the
Well,
margin.
if one looks at the sentence at the top of 324, the conclusion is the effect of maintaining the WRS will be...
Seeking to draw your attention to the contrast between those two succeeding sentences.
I understand that, and certainly if one were reading this document as a statute, one might say, well, look, the wording is different. There are different wordings at different points. But when you read this document as a whole, in my respectful submission, what you get from it is a finding that the proper conclusion to draw from the analysis which this committee has undertaken is that there will probably be a small impact on inflows if the WRS is removed. And one takes that both from the summary and from the wording of 5.16. There are other places in the document where the word possible is also used, because the precise mechanism by which the inflows are to be affected.
The amalgamation of possible with will be produces probable, is that right?
Well, my Lord, I can't do better than the document I've got in front of me. Right. One has to make sense of the document as a whole. It's written by economists rather than by lawyers. And I say, when you look at this document as a whole, including the summary at the beginning of it, that does appear to me to be a summary which reports the conclusion that, in the committee's view, there is a probable impact of a small nature on inflows if you get rid of the WRS. Now,
you go on to 5.17. I think,
yes.
Looking at the converse question.
Yes, I mean, they are definitely distinguishing between substantial effects, which they say there is no evidence to indicate, and small effects. And so the question is, depending on whether proportionality review applies at all, whether the small effect that they have identified is sufficient or not. And that's obviously the question at the heart of this case.
But I think you make a fair enough point that this is written by an economist, but ultimately it has to be assessed by decision makers.
Yes, of course. There's no doubt that the benefit which this report identifies is a small benefit. And I can't get away from that. I don't seek to get away from it. I'll just show you the remaining parts of the report.
Before you leave 5.17,
yes.
could read it as saying it wasn't going to affect things to any degree which was significant.
Well, the word substantial is used in some parts, and the word significant is used in others. And
significance a value judgment, and the others are a measure.
Well,
maybe.
Yes, but your ladyship will have seen that the ultimate question the MAC was being asked here was whether it was sensible to retain the WRS, and they came to the view ultimately that this was a value judgment for them. Yes, it was sensible to. Why did they do that? Well, because the effect of maintaining the WRS will be to slightly reduce flows, and we don't want to exacerbate a position that is already very bad. I'll just show you the remaining paragraphs, 522. And following, discussion of the other likely economic impacts of removing the WRS, reduced ability to assess immigration flows due to lack of data, a negative impact, elimination of an administrative burden on employers, a positive impact, and increased expenditure on benefits, a negative impact. The ultimate conclusion on these is at 536. Abolishing the scheme would potentially lead to additional public expenditure in terms of increased benefit payments to A8 immigrants, although the sums involved would be relatively small. There would also be a loss of data. On the other hand, there would be some easing of administrative burdens on employers and the immigrants themselves. And then the conclusions, the ultimate. Sorry. I'm asked by my friend to invite you to look at 5.35 as well. Probably only a marginal effect. Nevertheless, plausible to argue that the abolition of the WRS could potentially result in a small positive impact on immigration inflows. Then the conclusions are at 328 to 329. 6.6, we emphasise that any impacts resulting from removal of the WRS would be small. Nonetheless, we believe that it would be sensible to retain the WRS for 2 more years due to the possibility of small but adverse labour market impacts from abolishing it. 6.7, the government will justifiably want to weigh the above factors against the longer-term aim of free movement of labour within the EU in the spirit of the Treaty of Accession. However, in the immediate future, even if retaining the WRS has only a small positive impact, that would be important to the domestic workers affected. Furthermore, the restrictions can only be maintained for 2 more years, beyond which the worst of the labour market disturbance will hopefully be over. And then the other factors are mentioned, including in particular at 6.10, the loss of data. So that's the MAC report, and I'll come back obviously to what we say about that in terms of issue 2, which is the proportionality issue. But as you know, our primary argument on issue 1 is that proportionality review simply doesn't apply in this circumstance. Now, ladies, lords, I'm going to set out our case on issue 1 in three parts. The first issue arises from Mr. de la Mare's submissions, and those submissions raise the question, does paragraph 5 of chapter 1 of Annex 8 to the Act of Accession impose a requirement on a member state that wishes to extend its national transitional measures to show that those measures are, quote, materially capable of reducing the flow of incoming A8 workers and thus reducing the serious disturbance in the labour market. That is Mr. de la Mare's submission at paragraph 19.1 of his case. Now, this alleged requirement, materially capable of reducing the flow of incoming A8 workers and thus reducing the serious disturbance in the labour market, appears to be framed with the intention of ruling out action based on something like the MAC report that we have just seen, namely action designed to avoid exacerbating an existing serious labour market disturbance. If so, we say it is wrong. Under paragraph 5, a member state has to show 2 things and 2 things only. First, that there is a serious labour market disturbance or threat thereof. And secondly, that it has notified the Commission of its intention to extend the measures. And that is all.
What's the point of requiring a serious disturbance of the labour market if it doesn't have to have any sort of relationship to the measures continuing? What's the point of putting it in there at all?
Well, I can accept if the point that is put against us is that there has got to be a rational relationship to the serious disturbance, then I can accept the point if it's put in that way. And you've seen from the MAC report that the MAC report does indeed say that there is a relationship between these measures and the serious labour market disturbance. And the relationship is, if you remove the WRS, you will exacerbate the serious labour market disturbance. That's the relationship. But if you are going to imply in additional words by use of terms like material, which are designed to place a jurisdictional threshold on exercise of the paragraph 5 power, which is not there in the terms of the provision, then we say that is reading too much into paragraph 5, particularly when one looks at that paragraph in comparison with the other provisions of Chapter 1 of Annex 8. The second question, which I'm going to come to, is obviously the central question in the appeal, which is, does a decision to extend the national measures have to be proportionate? As to that, we say there is clear Court of Justice authority that if national measures fall within the scope of the derogations in the Act of Accession, the question of proportionality in the light of the treaty provisions guaranteeing free movement does not arise. And that being so, it is, we submit, conceptually incoherent and contrary to the intention of the parties to the accession treaty to read in a materially identical proportionality review under the guise of a general principle of EU law. Put shortly, if you can't have proportionality under the treaty provisions guaranteeing free movement, which the Court of Justice has said you can't, then how realistically is proportionality under the guise of a general principle any different?
But you accept that there's ordinary judicial review principles would apply, and
yes.
there's sort of Padfield principles would apply, yes.
And yes, indeed.
So there's a significant distinction between
yes.
that and...
Well, my Lord, I mean, if it were said against us, for example, that the decision to make the instrument which extended the workers' registration scheme were irrational, it's a matter of domestic law, then I accept the instrument would be unlawful if that could be shown. But we do respectfully say that this is one of the cases where there is a real distinction between proportionality review, potentially, and rationality review. And if one looks at a document like the MAC report, which is a nuanced document that does not overstate the case, but nonetheless concludes that it would be sensible to retain the WRS, it is, in my respectful submission, very difficult to say that, and indeed that the respondent has not said at any stage that decision would be amenable to challenge on domestic rationality ground. It wouldn't be, because a minister could perfectly properly read the MAC report and conclude that it was proper to extend the scheme. The third question under issue 1 arises if we are right on questions 1 and 2, and that is proportionality review available anyway because of Article 14, read with Article 1 of Protocol 1 to the ECHR? And we say no, because once it is established that under the accession treaty, A8 nationals in Ms. Gubeladze's position do not enjoy free movement rights, their position cannot be relevantly analogized to that of nationals of the member states which joined prior to 2004. Or, to put the point another way, the differences in their treatment reflect and are objectively justified by the different status accorded to them by the accession treaty. And I'll come on to show you the cases both in this court and in Strasbourg that make that point, where discrimination is alleged. I know that some members of the court, and Lord Carnworth in particular, will be familiar with those cases, having been the author of some of the judgments, that there are a number of cases where an EU right is asserted, but if the EU right is not made out, a subsidiary case is made based on Article 14, read with Article 1 of the first protocol, and the answer tends to be that the distinction is or reflects a distinction in EU law and is therefore not contrary to Article 14. As to the first question, our submissions are summarised in the reply note, which I hope you all have. And can I just make my submissions really by reference to that reply note? Picking that note up at paragraph 6, we say that the language, the drafters could have said, if you like, that member states could extend their national transitional measures if, without such measures, there would be a serious disturbance of its labour market or threat thereof. It could have said that member states are permitted to enact such measures if and to the extent necessary to restore to normal serious disturbances of its labour market or threat thereof. Those precise words were used in Article 7. Similar words, in order to address, were used in Article 13, but you do not find them in Article 5. So that's the first point. The second point, see paragraph 7 of our note, is that the drafters envisaged that some member states, they clearly envisaged that some member states would exclude A8 nationals from their labour markets completely. In fact, all but 3 existing member states did so by imposing work permit requirements. In those states, if there was a serious disturbance in the labour market at the 5-year point, that disturbance could not, as a matter of logic, have been caused by the influx of A8 nationals. They hadn't been admitted to the labour market in the first place. So it can't sensibly be suggested that the only thing that counts is a disturbance caused by an influx of A8 nationals. Third, see paragraph 8, the discretion conferred by paragraph 5 is a discretion to continue to apply these measures, i.e. the ones adopted initially. But if there has been a serious disturbance of the labour market due to the influx of A8 nationals, despite the existence of national transitional measures for the first 5 years, how could continuation of the same measures ever be capable of materially reducing the flow of A8 nationals? Put another way, there is nothing in the text of paragraph 5 to prevent a member state from extending its national measures so as to avoid exacerbating a serious disturbance caused by factors other than an influx of A8 nationals. Nothing to suggest that a member state cannot act on the basis that you have seen in the MAC report. We have a terrible situation. It's not been caused by an influx of A8 nationals. It's been caused by something external, the financial crash. But we have concluded that that getting rid of the registration measures, the workers' registration scheme, will exacerbate that currently dire situation.
It's right, is it, that they have the same measures you continue?
Yeah, it is. If one looks at the wording of the treaty, that must follow from the wording. And can I try and answer that point more particularly by looking at the accession treaty itself? The Annex 8, is in Bundle 1.1, tab 4, and it's at MS 597. So paragraph 5 confers a discretion to continue to apply these measures, and these measures must refer back to the measures which are referred to in the preceding paragraphs. In other words, the ones that had been introduced first time round. And to make that point good, one can see from paragraph 12, which is on 598, that there is a specific power to introduce under national law greater freedom of movement than that existing at the date of accession, but not less. So
although the UK could have restricted it altogether at the beginning, it can't adopt that as a way of addressing the serious disturbance.
No, it can't. So the choice available to it at that stage was, well, you can either continue these measures or, see paragraph 12, you can, if you want, you can have greater freedom of movement. You can get rid of the measures altogether, or you can have greater freedom of movement. But what you can't do is say, well, we're now going to go back to a system of work permits, and as every other member state apart from Sweden and Ireland had done originally.
So it could have reduced, I mean, the suggestion was it might have reduced the registration fee.
You could do that,
you could do.
Yes, because that would be introducing greater freedom of movement. But as the MAC pointed out, its main rationale for keeping the scheme was indeed to confer a small protective benefit on the UK labour market. And since the £90 registration fee was one of the principal mechanisms by which that was going to be achieved, it did not recommend reducing, indeed it specifically considered and ruled out taking away the fee. But yes, to answer my Lord's question, there was essentially a binary choice open to the government at the point where it was considering extending. Either you keep the measures that you already have, or you get rid of them. And so that's where we were at the time. Now, given that that is so, and that was the choice, if there has been a serious disturbance of the labour market due to the influx of A8 nationals, it couldn't be the case that continuation of the same measures would be capable of reducing that influx. The fourth point which we make at paragraph 9 is that the cases relied upon by Mr. de la Mare, and I'm not going to go to those cases, but I'll just give you the references because there's quite a lot to get through, to establish that provisions in accession treaties must be interpreted strictly, in fact established just that they must be interpreted according to their strict terms. That's actually what the cases establish. We say amen to that because it is we who are interpreting paragraph 5 according to its strict terms, not Mr. de la Mare. And the particular case that illustrates that point best is one of the ones that he cites, the case of Kapal Oy, which is in Authorities Bundle 1-2, tab 17 at MS 1014. We commend in particular paragraphs 19 and 20 on MS 1031 as supporting the strict interpretation of the provisions. Another point that arises from the same case at paragraphs 22 to 23 on MS 1032 is that unilateral statements of member states are not admissible as aids to construction in relation to accession treaties. least in circumstances where the wording of the unilateral statement is not reflected in the wording of the treaty. Can I turn now to the central issue in the appeal, which is whether EU law requires proportionality review. Now, the key authority on this aspect of the case is the decision of the Court of Justice in Vico Plus, and we say it supports our case that proportionality review does not apply. And I invite you to look now at volume 1-2, tab 22, MS 1147. So we can take the facts from the opinion of the Advocate General, at paragraph 2 on page 1150.
Sorry, page?
1150.
Thank you.
Vico Plus had been fined by the Dutch authorities for posting Polish workers to the Netherlands without work permits. Paragraph 3, you can see that the case turned on the interpretation of Annex 12 of the Act of Accession, which deals with Poland. From paragraph 7 over the page on 1151, second right-hand column, the provisions in question are there set out, and they are materially the same as the ones that we're dealing with. Paragraph 19 on 1155 is important. Consequently, says the Advocate General, the referring court wonders whether, with a view to protecting the domestic labour market, the requirement of a work permit under the relevant Dutch law is a proportionate measure in the light of Articles 49 and 50 EC, in view also of the reservation made in Chapter 2, Paragraph 2 of Annex 12. Now, 49, just to recall, is now 56 TFEU. It's the freedom to provide services. And the reason that that was relevant is because the party before the court was not the accession state national himself or herself. It was a company which was providing services consisting in the posting of those accession state nationals to the Netherlands. So that's what was troubling the referring court. We were wondering if this is a proportionate measure in the light of Articles 49 and 50. And it was in those circumstances, as can be seen from paragraph 21, that the referring court asked the questions set out. And question 1 was, must Articles 49 and 50 be interpreted as precluding a national measure such as this? From 23 and 24, on page 1156, one can see that the problem arose because hiring out of manpower constitutes the provision of a service, but also concerns freedom of movement. And the Act of Accession contains a specific derogation in respect of freedom to provide services, but, as we saw, only for Germany and Austria. So, see paragraph 25. The first question should be reformulated in order to focus the interpretation on the transitional provisions in the 2003 Act of Accession. I therefore take the view that the court should examine whether the hiring out of manpower falls within the scope of the derogation referred to in Chapter 2, Paragraph 2 of Annex 12 to the 2003 Act of Accession. Only if that were not the case would it be necessary to examine whether the measures contained in Netherlands law constitute a justifiable restriction on the freedom to provide services. So that's the view that the Advocate General gives. And there are 3 points to note at this stage. First, the question is whether the relevant activity, quote, falls within the scope of, unquote, the derogation. Second, if it does, the question whether the measure is a justifiable restriction, and for justifiable restriction read proportionate restriction on the freedom to provide services, does not arise. Third, there is no suggestion that the question whether the measure is proportionate arises under any other guise or in any other form, such as, for example, under the guise of a general principle of EU law. So then skip forward to paragraph 46. Page 1160, where Advocate General Bull notes that it is settled case law that a transitional provision, as a derogation from the principle that provisions of EU law must apply immediately and fully to the new member states, must be interpreted strictly, Mr. de la Mare's point, and in such a way as to facilitate achievement of the objectives of the treaty and applications in full of its rules. At 47 on the next page, 1161, he indicates the need to examine the purpose of the transitional provision in order to determine its scope. And at 48, he indicates that the purpose is to prevent disturbances on the employment market following accession. And at 49, that the derogation must be interpreted in the light of that purpose. 50 to 51 applies that purposive construction and concludes that the provision does include hiring out of manpower. And note here that the purposive construction is one which affords fuller protection to existing member states, not one which accords fuller protection to A8 nationals. Because that's what was being done by these provisions of the Act of Accession. It was protecting existing member states. Now the court adopts, we respectfully submit, the same approach. And one can see that from looking at the way that the court poses or understands the question it has been asked at paragraph 18 of its judgment at 1179. It encapsulates what it understands to be the essence of the question asked as whether, with a view to protecting the domestic labour market, the requirement of a work permit under the Dutch law is a proportionate measure in the light of Articles 56 and 57 TFEU. In view also of the reservations set out in the Act of Accession. So that's what it understands to be the question that it's been asked. Then at 22, there is an important passage which you sometimes see in ECJ judgments and sometimes don't. But you do find it in this judgment. And it indicates that the court isn't bound to stick like glue to the questions asked and is not precluded. Sometimes, of course, the court does stick like glue to the questions asked, but sometimes it quotes this passage, which often appears in precisely these terms, indicating that it isn't bound to stick like glue to the questions asked and is not precluded from providing to the national court all elements of interpretation which may be of assistance to the national court in adjudicating on the case. Having then said that, it gives an answer at 24 in terms which mirror those used by the Advocate General. if national legislation is justified pursuant to one of the transitional measures referred to in Article 24 of the Act of Accession, in this case, the measure provided for in Chapter 2, Paragraph 2 of Annex 12, the question of the compatibility of that legislation with Articles 56 and 57 can no longer arise. And just in case we don't know what's meant by the word justified, it's cashed out, if you like, in the next paragraph, 25. It is therefore necessary to examine whether legislation such as that at issue in the main proceedings is covered by that transitional measure. Um, 26 to 33, which I'm not going to read out, then answer that question in the affirmative as a matter of textual analysis without at any stage examining the proportionality of the measure. 34 refers back to the purpose of the measure, which is to prevent disturbances on the labour market of the existing member states. And 41 gives the answer to the first question, which is, in unqualified terms, that Articles 56 and 57 do not preclude a member state from making, during the transitional period provided for, the hiring out on its territory of workers who are Polish nationals subject to the obtaining of a work permit. Now, we make 5 points based on that judgment. First, the reason the Dutch court referred a question about the compatibility of the Dutch measures with Articles 56 and 57 was because it was concerned that the measures might be disproportionate. See Advocate General's opinion, paragraph 19, Court's judgment, paragraph 18. Second, the answer given both by the Advocate General and by the Court was that if the measures fell within the scope of the derogation, see paragraph 25 of the Advocate General, or were covered by it, see paragraph 25 of the Court's judgment, no question of their compatibility with Articles 56 and 57 could arise. Third, consistently with this approach, neither the Advocate General's opinion nor the Court's judgment contains any analysis of the proportionality of the measure or any principles that could be usefully adopted by the National Court in deciding that question, despite the fact that concerns about its proportionality were one of the reasons the Dutch court referred the issue. Fourth, if, as the respondent argues, the words justified pursuant to in paragraph 24 of the Court's judgment meant both within the scope of and proportionate, the Court could not have gone on in paragraph 25 of its judgment to use the words covered by and could not have given the unqualified answer it in fact gave that Articles 56 and 57 do not preclude the national rules in question. It would have had to say that Articles 56 and 57 do not preclude those rules provided that the National Court assesses them to be proportionate, or words to that effect. Fifth, if proportionality review comes in not under Article 56 and 57 TFEU, but rather under the guise of a general principle of EU law, one would expect the Court to have said so, particularly in light of the express reference in paragraph 22 to its power to go beyond the words of the questions referred and provide the National Court with all the elements of interpretation which may be of assistance in adjudicating on the case. One can go a little further and say that if proportionality review, under the guise of a general principle, does indeed apply, the Dutch court might be forgiven for thinking that the answer it had been given was a spectacularly unhelpful one.
One's tempted to say it wouldn't be the first time.
Well, that may be so, lady, but I think having seen the way that the court put the answer it gave, and in particular...
Completely take your point on what the court did, yes.
One has to do the best one can to interpret what the court was actually saying here, and we do say it would be very unhelpful if the true answer was, but we haven't what we haven't told you is that precisely the same analysis comes in under another guise. Now, I want to try and support the conclusions that we draw from Vico Plus from a more theoretical standpoint. And we set out our argument at paragraph 28 of our case. I want to just show you that and then go to some of the authorities that we refer to there. It's at MS 129. So at 28, proportionality review necessarily involves, we say, as an essential component, assessing the degree to which an impugned measure interferes with some protected interest. And we've cited three analyses that support that position. The first, and I can give you the reference without going to it because it's set out here in our case, is Advocate General Dutheillet de la Motte's seminal opinion in the International Handelgesellschaft case, Authorities Bundle 2.1, tab 48, MS 1740. And he says the fundamental law invoked here that the individual should not have his freedom of action limited beyond what is necessary in the public interest is already guaranteed both by the general principles of community law and by an express provision of the treaty, which in that case was Article 40 of the Treaty of Rome. We say that formulation necessarily involves the prior identification of a freedom of action, that's the word he uses, that is recognised and protected by the law. Professor Tridimus makes a very similar point. The principle comprises two tests, a test of suitability and a test of necessity. The first refers to the relationship between the means and the end. The means employed by the measure must be suitable, namely reasonably likely to achieve its objectives. The second is one of weighing competing interests. The court assesses the adverse consequences that the measure has on an interest worthy of legal protection and determines whether those consequences are justified in view of the importance of the objective pursued. Now, we say inherent in that is the identification of a, quote, interest worthy of legal protection. And that point is made also by Professors Craig and de Burke in the latest edition of their book on EU law. In any proportionality inquiry, the relevant interests must be identified and there will be some ascription of weight or value to those interests, since this is a necessary precondition, or precedent rather, to any balancing operation. Now, those statements of academic principle are, we say, what lies behind the proposition that you find in Lumsden's case at Authorities Bundle 1.3, tab 29. 1373. Paragraph 25. If one goes back to 1372, this comes in the discussion, the court's discussion, Lord Reid and Lord Toulson's discussion of the principle of proportionality in EU law. And at the end of paragraph 25, you see this important statement: the principle only applies to measures interfering with protected interests. Reference is then given to the British sugar case. Such interests include the fundamental freedoms guaranteed by the EU treaties. They're not limited to those interests, but they do include those interests. We say that is all consistent with the academic work indicating that you need as a first conceptual stage in any proportionality analysis to identify what is the interest that the measure you are impugning is interfering with. And until you've identified that interest, you can't perform the task of weighing up the degree to which the measure will produce a social benefit on the one hand against the degree to which the measure interferes with a protected interest. Of course, the protected interest can be something else. It doesn't have to be one of the fundamental freedoms, but it has to be an interest which is protected by the law. Now, there is no doubt that a measure such as the Workers' Registration Scheme does affect the interests of AA nationals. It does so, as a matter of fact, to a lesser extent than would be the case if a work permit system had been in place, as it was in every other member state apart from Sweden and Ireland. But the interests that it affects are AA nationals' interests in free movement and residence as workers, and their interests in receiving social assistance benefits available to workers. Those are the interests to which the parties to the accession treaty decided not to give legal protection in the case of AA nationals, unless and until the AA national had worked legally in the host member state for 12 months. Our point on this aspect of the case is a short one. If you subject the decision to extend the Workers' Registration Scheme to proportionality review under the guise of a general principle, what you are in substance doing is saying that the intrusion into free movement interests of AA nationals is not justified by the social benefits that the extension of the scheme may be expected to bring. And, Lords and Ladies, that is precisely what Upper Tribunal Ward did when he undertook the proportionality analysis. And I'm going to come back to this later under issue 2, but can I just show you one passage in Upper Tribunal Judge Ward's decision? You know that Upper Tribunal Judge Ward was the one who conducted the proportionality analysis. The Court of Appeal said yes, there was no error with that. So we need to look back at his original analysis. And you find this in the core volume at MS 273. He draws two conclusions. One is that the extension of the scheme is not an appropriate means of achieving the objective. But then he goes on to conduct the analysis that some of the authorities refer to as proportionality stricto sensu. In other words, the weighing up of, on the one hand, the social benefit that is sought to be achieved by the measure, against, on the other hand, the degree of intrusion into a protected interest. And he says this at 117 on 273. I do not base this decision on whether the means adopted were the least intrusive means. Pausing there, most proportionality analyses where the proportionality challenge succeeds are indeed based on some analysis of least intrusive means. But here, he says, rather, the small and speculative advantage is wholly outweighed by the disadvantage to A8 nationals and employers and the limitation on treaty principles of free movement, even allowing for the argument that every little helps in the difficult circumstances which the economy faced. So what Upper Tribunal Judge Ward was doing here was, in substance, precisely what the Court of Justice has said in Vico Plus should not be done. In other words, he has accorded, under the guise of a general principle of EU law, precisely the protection that would be given if, contrary to the express provisions of the accession treaty, the free movement provisions applied. The conclusion, we say, is straightforward. Once it's established that a measure such as the scheme, or an extension of it, falls within the derogation in paragraph 5 of Chapter 1 of Annex 8, questions as to the proportionality of the measure cannot arise. Now, I recognise, of course, that that conclusion is contrary to the decision of the House of Lords in Zalewska. So I need to just look at that case, because, as I said before, I'm inviting, respectfully inviting you to depart from it. Now, Zalewska is in Volume 1, 3. Tab 33, and it starts at MS 1516. And you'll see at paragraph 20...
Sorry, 103 tab?
13, tab 33, MS 1516.
Thank you.
That's where it starts.
That's where it starts, yes. If one then goes forward to paragraph 25 in this speech of Lord Hope, which is on 1526, one can see that the first question is whether the appellant can rely on Article 39 and Article 7.2 of Council Regulation 1612 of 68 to qualify for income support, despite the fact she was not authorised to work for an authorised employer under Regulation 7 of the 2004 regulations for the whole 12-month period. And I mentioned before, when I was going through the provisions, that the answer given in this case was, no, you can't, although it's only Articles 1 to 6 of Regulation 1612-68 that are disapplied by the accession treaty, you can't rely on Article 7 either, because Article 7 is a right that is only given to those who enjoy Articles 1 to 6. And that is essentially the conclusion that is here reached. So in 26, we see that absent a derogation, nationals of any member state, including A8 nationals, could rely on the same rights of access to the labour market and to the social advantages that go with them as those of any other member state. But that was subject to the derogation. The effect was to enable the UK to lay down its own rules for access to its labour market by A8 nationals. Then at 27 over the page, starting at the bottom of the page and going over to 1527, Lord Hope deals with an argument that Article 7 continued to apply because it was not specifically mentioned, and he rejects that argument. He rejects it because, as I said, Article 7 confers on workers the right in the host member state to equal treatment in relation to social advantages, but the right is conferred only on workers, and it's Articles 1 to 6 that confers the status of worker. Since those are displaced by the accession treaty, you don't become a worker unless you comply with the national measures. Now, that is, of course, entirely consistent with the judgment of this court in Mirga, which we saw earlier. Then at 29, so no difficulty with the judgment.
No, you like it so far, yes.
Like it so far, yes. Then at 29, you can see set out the argument made then on behalf of the Secretary of State by Mr. Lewis, as he then was, to the effect that the UK had a complete discretion to determine the conditions on which nationals may obtain access to the labour market. That's the argument there set out. The argument is rejected at paragraph 30 because Lord Hope could not accept that the national measures the UK adopts have nothing to do with community law. So he was rejecting an argument that there was a complete discretion because the question whether to extend or whether to adopt measures under paragraph 2 simply lay outside the scope of EU law. The derogation was agreed to under the umbrella of community law, says Lord Hope, later on in that paragraph, and it was not possible to detach the opportunity that's given to the member states to apply national measures from its community law background, and the conclusion that national measures must comply with the principle of proportionality flows from that. Now, at this stage, can I make 3 points about the judgment, which on this point was a unanimous judgment of the House of Lords. First, as can be seen from paragraph 30, the fundamental proposition which Lord Hope could not accept was that the national measures the United Kingdom selects have nothing to do with community law. As I hope I've made clear, that is not my argument. A member state's decision to adopt or extend national measures plainly has to do with community law, in that it has to comply with the express limitations in the Act of Accession. It could not, for example, adopt measures which exclude from its labour market A8 nationals who have worked legally for a continuous period of 12 months. And it could not extend its national measures from 5 to 7 years after accession if there was neither a serious disturbance of its labour market nor a threat thereof. Those are conditions precedent to the exercise of the discretion laid down by the treaty. In that sense, the decision of a member state to adopt national measures is a decision that has to do with, or if you like, is governed by EU law. But, and this is the second point, the silent premise of Lord Hope's analysis is that whenever a decision is governed in this sense by or has to do with community law, or cannot be detached from its community law background, the principle of proportionality applies. But that is not the case in our respectful submission, because the application of the principle of proportionality requires the antecedent identification of a protected interest, and because the treaty provisions that govern the member state's decision were themselves designed to make clear that the relevant protected interest does not arise. The third point is that Lord Hope's analysis precedes the Court of Justice's judgment in Vico Plus, and so does not answer the question how, if the issue whether a national measure is proportionate in the light of the treaty provision does not arise, how proportionality review can nonetheless be available.
I assume that Zalewska was not referred to in Vico Plus.
No. Wasn't. No reason.
No reason why it should be.
No reason why it couldn't.
No reason why it should be. But
it was a Dutch reference to the European Court of Justice, and it wasn't. Is the answer.
Well, if your argument is right, there's an obvious and direct clash between the two authorities.
Lord, I respectfully agree. So for these reasons, we submit that on this point, Zalewska should not be followed. Now, I see the
It
time.
seems to, from the way in which Mr. Lewis argued it, it seems fairly clear that he was saying proportionality has got nothing to do. I can't remember what he argued. It's a long time ago.
Oh, he was definitely saying that.
He was definitely
yes.
saying
There's
that
no
proportionality
doubt.
doesn't apply. Yes.
There's no doubt that he was saying that.
Yep.
That's why we made absolutely clear in our application for permission to appeal that we were indeed inviting the court to depart from Zalewska.
Yes,
I
yes,
can't
yes.
say that the
Well, it's
decision
unfortunate,
doesn't
isn't it,
apply.
because it's only reported in the WLR, and so we don't have a synopsis of his
We don't.
argument. But you would say that we have to deduce that he was applying that. He was arguing that because of paragraph 29.
Yes.
Yeah.
So, so that's where we are in terms of the central issue on under issue 1.
Has there been any academic commentary on that aspect?
Not that we have been able to discern. No.
And I mean, presumably it is for comment, is this right, that the government didn't ask for a reference on the question of the application of the principle of proportionality?
I don't know whether it did or not, but there's nothing to indicate that it did. Your Lordship is absolutely right about that, although it is also...
People make mistakes, I mean,
It's
presumably you would say.
There's that point, and there's also the fact that, of course, the argument I'm making is based largely on Vico Plus, which, of course, wasn't available to Mr. Lewis when he argued the case. So he wasn't able to say to pray and aid Vico Plus in support of his argument at that stage. So that's where we are on issue 1. The next part of my submission, which I'll take up at 2 o'clock, if I may, is our response to the argument, well, none of this matters anyway, because you get the same proportionality analysis under Article 14 read with Article 1. I hope I can do that relatively briefly by reference to our reply note, but not now.
No, not now. We'll look forward to hearing from you at 2 o'clock, and we'll adjourn now.